In today's video, we're covering 3 short but important sections that directly affect how agents, clients, and the MLS operate. Section 20, Selection of Service Providers, Section 21, MLS Authorization, and Section 22, Attorney Fees and Costs. We'll explain 1. Why agents are not responsible for the performance or quality of vendors and service providers. 2. What happens to property photos, videos, and information once uploaded to the MLS or internet portals. 3. Why images cannot be removed after closing due to MLS rules and legal requirements. 4. How attorney fees and costs are handled if a dispute arises between buyer and seller. 5. Explanation of the prevailing party rule. The losing party may be required to pay the other side's legal fees. Even though these sections are brief, they contain important protections and disclosures every agent must understand. Let's jump into sections 20, 21, and 22 of the RPA. Section 20, Selection of Service Providers. What the clause says in plain English: 1. Agents do not guarantee the performance of any vendors or service providers. 2. That's true even if the provider was referred by the agent or chosen by the buyer, seller, or anyone else. 3. Buyer and seller are free to choose any providers they want. Section 21, Multiple Listing Service, MLS. What this paragraph authorizes: agents are allowed to report to the MLS that an offer has been accepted. After close of escrow, the sales price and key terms of the transaction will be sent to the MLS to be published and shared with authorized users. Buyer acknowledges 3 big things. 1. Images stay after COD. Any photos, videos, floor plans, or other property information that has been or will be entered into the MLS or internet portals will not be removed after closing if entered under seller's instructions or MLS rules. 2. Law requires retention. California Civil Code Section 1088C requires the MLS to keep those images and information for at least 3 years. Because of that, they may continue to appear and circulate on the internet, and neither seller nor agents can control every website that copies them. 3. No obligation or ability to scrub the internet. Seller, seller's agent, buyer's agent, and MLS have no obligation or ability to remove those images or information from the internet. Section 22, Attorney Fees and Costs. If there is an action, proceeding, or arbitration between buyer and seller arising out of this agreement, the prevailing party, who wins, is entitled to reasonable attorney fees and costs from the non-prevailing party, except where paragraph 27A provides otherwise. Why this matters: 1. Encourages serious, good faith claims only. If you sue or arbitrate and lose, you may be ordered to pay the other side's attorney fees, not just your own. 2. Makes mediation/arbitration clauses in paragraph 27 important. Parties should carefully read the dispute resolution section because this fee shifting applies to those actions too. 3. Key talking point for clients: if this ever goes to court or arbitration, the loser may pay both sides' attorneys. That's why we push hard for mediation and settlement first.